A hearty welcome to all of you out there in Zoom land, and welcome to our latest First Amendment Salon. I am happy to announce that Floyd Abrams, who has from the outset been a strong supporter of the salons and is on our advisory board, has now joined as a co-chair of the First Amendment Salon. So a hearty thank you to Floyd for his continued support, which we greatly appreciate. Today's panel focuses on a new book just published by Rod Smolla. The book is entitled Confessions of a Free Speech Lawyer, Charlottesville and the Politics of Hate. It is a mind-opening book about the intersection of racial justice and free speech. It is thus an even more timely topic in these days of immense racial strife. If you would know who Rod Smolla is, consider the following: law school dean, law professor, Supreme Court advocate, legal scholar, treatise author, casebook author, advisor to governors, and director of the Annenberg Washington Libel Reform Project, among other things. It all comes under the name Rodney Smolla. Rod, thank you very much for joining us today, and congratulations on the publication of your latest book, which I heartily recommend to everyone to purchase and read. It is well worth it.
Thanks, Ron.
To engage Rod in discussion, we are quite fortunate to have Mary Rose Papandrea, who is the Samuel Ash Distinguished Professor of Constitutional Law and Associate Dean of Academic Affairs at the University of North Carolina School of Law. She has served as a law clerk to Justice David Souter, and before that, as a law clerk to Judge Douglas Ginsburg of the Court of Appeals for the District of Columbia. Mary Rose's areas of expertise include constitutional law, media law, civil procedure, national security, and torts. She is, among other things, the author of numerous book chapters and scholarly articles on media law and First Amendment topics, and we are very fortunate to have her with us today. Mary Rose, welcome.
Thank you.
And with that, let the discussion begin. Mary Rose?
Great. Thank you so much for this invitation to participate in the salon, and in particular to interview one of the most interesting and I think provocative First Amendment lawyers of our time, and one of my mentors as well, Rod Smolla. As Ron was saying, you've worn many, many hats, and you've taken various positions. Some are quite controversial. You argued Virginia v. Black on the side of the cross burners, but you also represented the plaintiffs in the famous Hitman case from the Fourth Circuit, and more recently, the plaintiff fraternity suing Rolling Stone for its now retracted story about the gang rape on the campus. You've been called, in addition to all those lovely titles, lawyer, casebook author, and all of that, you've also been called traitor to the First Amendment, but in many ways, you've also been its hero. So I'm really looking forward to our conversation today.
Well, I am too, Mary Rose. It's great being with you always.
Great. So, of course, the focus of our discussion today is going to be your new book, which focuses on all of the events and personalities and cultural currents that led to the Charlottesville events in 2017. And so the First Amendment plays a role in what happened, but it also, your book tells a lot of stories about the political, social, historical, and cultural factors that gave rise to these terrible events. So I thought if you didn't mind, before we start diving into the First Amendment, you might talk to the audience here a little bit about these other factors that you so compellingly identify in your book.
You know, I think that I really didn't set out to write a legal book, and I didn't set out to write a book about the First Amendment so much. Well, one of my favorite authors is Eric Larson, who's written tons of terrific nonfiction books, Devil in the White City and In the Garden of the Beasts. He'll take an interesting moment in history, or a tragic moment in history, you know, something that people sort of know about, and he'll talk about it like a novelist, and he'll interweave all the different personal stories, and then he'll give you a kind of intellectual history behind that. And I love that kind of writing. I wish I had his talent, but I set out to do something along those lines, and not just to try to narrate the tragic events of 2017, but to try to place them in another context. And, we're all reliving, in a way, the same tensions and the same anger and the same frustration and the same forces since the murder of George Floyd and the roiling of our society that has taken place in the last 4 or 5 days. And it eclipses the same sort of crisis that we all went through in 2017 in Charlottesville. It seems to have greater intensity and anger attached to it, and a sense of injustice attached to it. But that was what I set out to do. Not write a book for First Amendment scholars. The folks listening to this, know as much First Amendment law or more than I do, and I didn't really write it for folks who are experts in constitutional law as much as for the general public, and trying to kind of make sense of these events in against the backdrop of these larger issues.
Which of these currents do you want to examine first? Would you like to explore a little bit of the personalities behind the alt-right movement? You spend quite a bit of time talking about the backgrounds of the various players, which I thought was very helpful. If you'd like to, you don't have to go through all of them because that would take a lot of time, but you might want to tell us a little bit more about some of the key players.
Yeah, so I remember a scene in the Blues Brothers in which John Belushi says, "I hate Illinois Nazis," and the Bluesmobile barrels into them, and they all go flying into a river. And if you think about it, that which conjured up the march of Nazis and white supremacists through Skokie, Illinois, a heavily Jewish suburb of Chicago. If you think about it, those racists seemed like a joke at the time the Blues Brothers came out. And they were made into a joke. They seemed marginalized and puny and incapable of being real threats. And what we now know, that's far, 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 far from true. And we've had, extraordinary, sad, contentious, racist division in the last 30 years. And racism took on a new character with the alt-right. It was suave and cosmopolitan and well-educated in many ways. People like Richard Spencer, the leader of the alt-right movement, was telegenic and extremely well-educated. And putting together all these different strains of right-wing movements, supremacist movements, to some degree old school, to some degree still influenced by people like David Duke, but far more sophisticated and organized, in part because of the empowerment of the internet. And so I've forgotten a lot of their names. They have a lot of crazy, bizarre names and pseudonyms and of strange platforms in which they organize and spout their rhetoric, and it was new to me. I mean, I had to really educate myself on those strains. So I'm not sure it's worth dwelling on it much more.
Oh yeah, no, but I do recommend that to the readers, just to learn more about what led these people to where they are. Why do you think Charlottesville was the location? Why Charlottesville?
Well,
what was the import for the alt-right?
Yeah. So there are a few things that came together. First of all, the start of what became Charlottesville was really the terrible shooting by Dylan Roof of people in the Episcopal Church in Charleston, the massacre of African Americans there while they were praying. And that led to a resurgence of calls to have South Carolina take down the Confederate battle flag, which remained in the South Carolina Capitol. And Nikki Haley, you may remember, the governor of South Carolina then, and then later in the Trump administration, the ambassador to the United Nations. Nikki Haley, to her credit, rose to the occasion after President Obama gave what I think was maybe his greatest speech, the eulogy to those slain people in that church. And in a state where it was not easy to do, she got the battle flag taken down from the capital of South Carolina in Columbia. And it's just a bizarre coincidence. I was in Columbia that day. We were attending someone graduating from the University of South Carolina's commencement. And that then led to this viral attack on all the symbols of the Confederacy, all the Robert E. Lee statutes and Stonewall Jackson statutes and other places in which there were symbols of the Old South, from New Orleans to Florida, across the United States. One of the things I talked about is I was dean of the University of Richmond Law School for a good long time and lived in Richmond, and lived only a block from Monument Avenue, which is one of the most beautiful streets in the United States, but it is one circle after another of monuments to Confederate war generals. I think Floyd Abrams may be with us. Floyd and I once were on a case together in Richmond on the Fourth Circuit, and I remember having lunch with him outside one of these Confederate monuments. We lived a block from the Robert E. Lee statue, and I would go there to walk my dog and play Frisbee with my kids, and I had a total blind spot to how offensive that monument was to people of color in Richmond. It didn't register with me, but it began to register with lots and lots of folks, and Charlottesville became one of the epicenters of that battle.
I just want to interrupt for a minute.
Yeah,
I think when you spoke about your revelation on what these monuments stand for, I thought of that as one of the many confessions in this book, that you were confessing that you had not really appreciated what they stood for and what they represented, especially to the communities of color.
Yeah, it's funny. I mean, I grew up in Chicago. I grew up in the North, but of course it also had its racial divisions. But by accident, I've spent a long time in the South at various places, at law schools in the South, and I was president of Furman, which is a university in South Carolina. And I've always had a visceral, negative reaction to the Confederate battle flag. I got that. But for reasons I don't understand and I feel guilty about, I'd see a Stonewall Jackson, statue of him on a horse and didn't think about it. I was dean of the Washington Lee Law School, named after Robert E. Lee. I didn't think that was like evil to be at a university called Washington Lee. So I don't want to ramble too much, Mary Rose, but I think that's one part of it, that the battle over those monuments in Charlottesville became intense. But now I think Charlottesville itself was a symbol, and the University of Virginia was a symbol of political correctness, hotbed of left-wing academics, the exact opposite belief structure of the alt-right supremacists. And the city of Charlottesville declared itself the capital of the resistance when President Trump was elected. And then you have two of the key players, Richard Spencer and Jason Kessler, who were the two key organizers. Spencer, the national figure, Kessler, the local organizer, who, guess what, are graduates of the University of Virginia. So this was a kind of perfect, in-your-face place to stage what, on its surface, was a battle to save these monuments, but of course, more deeply, in my view, was a racist and a supremacist provocation.
So one of the things I found interesting, and it's particularly timely now with the riots around the country right now, is the way the police prepared for the events in August and what they did and they didn't do. And one of the things you talk about in your book is actually the previous July, like right before this, there was a KKK march through the city, where I think the city acted in certain ways that may have set the stage inadvertently for the August confrontations. I wonder if you could tell the group a little bit more about what happened in July and what kinds of things happened there that really set the stage for a tinderbox in August.
Yeah, so Mary Rose, I think this is enormously important, in some ways the most important thing for us to be talking about right now, because we're so reliving this right now, and everyone is in an extremely difficult position right now in the aftermath of the understandable um, uh, anger over the murder of George Floyd. So I'll tell the Charlottesville story quickly, but I would invite some dialogue between you and I'm happy to hear your views on what we think we should be advising police to be doing right now, or the president of the United States to be doing right now with American military forces, or governors with National Guards. So there is a rap on the law enforcement community as to how they handled the events in Charlottesville. And I was appointed to this task force by Governor McAuliffe to be an advisor to it. And in my book, I was unable to bring myself to join the chorus of folks that condemned law enforcement in Charlottesville. They made some mistakes. The Charlottesville police made some mistakes. The University of Virginia police made some mistakes. The state police made mistakes. The National Guard made mistakes. The biggest mistake was probably not enough force, not enough people power, not enough barricades to keep the opposing forces apart, and poor communication and a timidness to come down on people when they started to get out of hand. The police were instructed to be passive. And I think because they thought that was the right thing to do to preserve people's First Amendment rights. And so that was it. Let me talk about some of the things that went wrong. You mentioned that there were actually three big racist events. There was a march in May, a tiki torch march that was designed to conjure the images of the Hitler Youth that shocked everybody in May in Charlottesville. Then the Ku Klux Klan wanted to do a march to try to rally behind the Stonewall Jackson statue. And by this point, most folks in Charlottesville were so mad at the racists that had arrived in May, and so determined this time not to be caught by surprise, but to organize counter-protests against them, that by the time the Klan was ready to come into Charlottesville in July, there were thousands of anti-Klan protesters and about 50 Klan guys that came in. Well, this put the police in a bizarre position, if you think about it. It's not an easy position because the protesters had a permit to be at that park where the Stonewall Jackson statue was. You had to get them from their staging ground, which was in a little town outside of Charlottesville, into the city. Then you had to get them close enough that they could walk in their Klan regalia to the park. And then you had to protect them for an hour while they made their racist speech in the park. So you have the police in what appears to be the unseemly position of providing a motorcade, a police escort, like the Klan are, celebrities, through the city. And then the police form this gauntlet, almost like the cheerleaders coming out before the NFL football team comes into the stadium, and they're facing outward to the counter-protesters with their backs to this 6-foot corridor where the Klan guys come marching through. So the optics were the cops are protecting the Klan. They've taken sides in favor of the Klan. And then as the unruly crowd began to shout and bottles got thrown and a few people tried to punch a little bit at some of the Klan members through the police lines, they dispersed the event, and then tear gas gets released on the counter-protest. So there was this dynamic that the cops are on the side of the racists. And that fed into years of perception, the very thing we're living through right now again. It came out of all of the violence following the Ferguson, Missouri, Michael Brown shooting. It fed into that narrative of Black Lives Matter and Antifa that the cops are really the enemy. So you had all of that going on. And then when the final big Unite the Right rally came, there was much of that same dynamic. The actual Unite the Right marchers were tiny in number compared to the counter-protesters. Yet there was this optic that the cops were there to protect the bad.
Yeah,
I don't think that was totally true, but it had that feel.
They're not like on the side of them, but they were trying to protect their right. They had a permit and they had a right to.
Right. To us as First Amendment people, it's the heckler's veto, and the modern don't let the hecklers shut down the speakers. And so they were. You're right, but not everybody gets that and sees that. And I think one of the dilemmas right now in the aftermath of the murder of George Floyd is, on the one hand, there's an impulse to descend with massive force on Minneapolis, to send in the National Guard, have every available officer you can. And of course, not just Indianapolis, but 30, 40 cities across the United States. On the other hand, the very exercise of that force has a tendency to create its own reaction, its own anger. And, if you go back, to First Amendment thinking, Louis Brandeis, one of his big insights in Whitney versus California is that when you suppress the speech you don't like, you make it stronger, and you create this kind of conspiracy theory view, and you actually give it strength. And that's a really, really difficult public policy choice. Hopefully things are the curve is starting to flatten a bit in terms of the anger levels, which are perfectly understandable. But it's a real dilemma for police right now, because on the one hand, being there in force may save some lives, may deter some violence, but it also may cause the pressure cooker to get more intense.
Yeah, I mean, you mentioned in your book about, I sort of read into it. You thought there might be some merit to the dissent. I think it is in Finer, one of the heckler vetoes case, where it says that it's not realistic to think that the police can always control the crowd and protect the speaker. Sometimes you can't protect the speaker, and I feel like right now we're living through this. We have the doctrine of the First Amendment to protect the speakers. That sounds great in theory, like we protect speech we don't like. The public square is open to all views, but at the same time, the reality of what that means. Even putting aside the optics, which, people just don't always understand how the First Amendment works, which is an ongoing frustration of mine. But even putting that aside, just what do you do as the police, and how do you avoid this ongoing narrative that the police are on the side of violence against Blacks? I mean, it's a horrendous situation. Another thing you talk about in your book about all these laws that are available for the police to use, like unlawful assembly and inciting a riot, and how they may not want to use those, or when they do use those, they're sort of vague and maybe subject to First Amendment challenge. So there seems to be a little bit of a disconnect between what the law says and on the ground reality.
Right. I think that if you were to listen in to the training sessions, the brief that a police chief or a local prosecutor might give to the cops as they anticipate events tonight in many, many, many American cities, you would hear terms that those of us in this discussion as First Amendment lawyers don't think necessarily connect with what we understand the First Amendment to be. So just take the simple notion that a police chief can, say, okay, I'm calling unlawful assembly. Kind of like, a referee giving somebody a yellow card or something. Unlawful assembly, I just called it. Well, how do we as First Amendment lawyers fit that into Brandenburg versus Ohio or Virginia versus Black, or the permitting requirements or prior restraint law or unbridled discretion and things like that? It's not a perfect match by any means.
What did you think of, we thought we might talk about the university's reaction as well. You were very nice, but you were critical of UVA, I think, of President Sullivan taking a non-confrontational, or sort of a passive approach to the August events, saying instead of engaging with them, we're going to engage in counter-programming. And so I'd like to talk.
Yeah, I don't know. I don't know that I was critical. I think I tried to, like Joni Mitchell says, see the world from both sides now. I mean, look.
You said it was very difficult.
Well, and I've been in that position. I've been a university president. I know it's in kind of these kind of hateful confrontations. So maybe here's the larger picture. The larger picture was there were a lot of folks, a lot of leaders across Virginia, across the country, a lot of clerics who said, these Ku Klux Klan guys are stupid. These alt-right guys are stupid. Let's just ignore them. And then there was a very different voice. It tended to be the younger clerics in the faith communities in Charlottesville, and I think it tended to be probably for the you know, a lot of the students at UVA and a fair number of faculty at UVA. And I don't want to say it was generational, like the young faculty was on one side and the more senior faculty was on the other. I think there were divisions. But there was this counter notion that says we can't just sit by and ignore this kind of stuff. This is our town, this is our campus. This is evil speech. We have to confront it, and we have to shout it down, and we have to show massive, presence in response to it. And I think the President Sullivan's reaction, which was not unusual, was let's ignore them and let's have good counter programming. And that's very, very admirable. I guess it probably in a way underestimated the intensity of the anger that these messages provoked. And if you'll just get one other sort of observation, I just happened this morning to listen to a wonderful, fascinating interview on CNN of one of my sports heroes, Kareem Abdul-Jabbar, who has since become an extraordinarily interesting and a wonderful intellectual and leader. And he pointed out the similarities between the George Floyd video and the Rodney King video of 30 years ago. And it's so easy and it's so pat for us to say, oh, there's a right to freedom of speech, but there's no right to be violent. There's no right to burn a car. There's no right to throw a bomb. And of course, that's true. But what Kareem Abdul-Jabbar said is, to a lot of these folks, they don't feel they have any voice. And they've seen zero progress from Rodney King to George Floyd. And yeah, they pour out in the streets and they scream obscenities and they get mad and they're viscerally angry at cops, maybe at cops that don't deserve our anger because they're not racist, they didn't do anything wrong. And then sometimes they just go over the top. And he didn't condone the violence, but he said you have to understand the anger and frustration from what it is coming. And for a lot of folks, it's the only way to kind of feel they're breaking through and they're communicating.
Yeah, one of the things that, with the riots now, they're not permitted, so all the discussions of, what can we do when we have someone who seeks a permit for hate speech, that there's some very interesting and knotty First Amendment questions that I know you've been grappled with. And you mentioned Leslie Kendrick in your work, and she's written about this as well. What can cities do? So putting aside the riots just for a moment, right. I know they're on everyone's mind, but as far as if we have these very conservative alt-right speakers who may or may not themselves be threatening violence directly, because if they were, it might be an easier call. But they're upsetting, they're offensive. Are there any tools that cities can use to lessen the likelihood of another Charlottesville?
Well, I think very few, and very few that I would endorse. I mean, so I'm a real First Amendment purist in this, and I think the formal doctrine is good. And I talk about one of the classic cases, the Forsyth County, Georgia case that involves some of these same confrontations. But, the Supreme Court's rules are pretty straightforward. Whatever permitting scheme you have has to be, scrupulously content and viewpoint neutral. Even things like how much money you charge for, what kind of a bond you require or how many toilets you require, things like that have to be worked out in advance and be very content neutral. Cities can, place maximum occupancy rules on a park. How many people can be squeezed into this square or squeezed into this plaza? And you can do those kind of routine crowd control things. I know that in the aftermath of Charlottesville and a lot of the tours that a lot of racist folks took of American universities, people suggested you could just charge the heck out of the people that want to protest for the costs of providing protection. So one of my oldest friends, Erwin Chemerinsky, with whom I started teaching together, offices side by side a long time ago at DePaul Law School in Chicago. Erwin suggested that Berkeley could charge $500,000 or something like that for to protect, the university expense. And I'm on the opposite side of that. I think as a society we have to subsidize this and treat it as part of the overhead of free speech. So there aren't many tools other than the kinds of things that we've already been thinking about: physical barriers, keeping the crowds physically apart. I made what may seem like a dumb suggestion, but to me, if you're going to deploy lots of troops and you have at least two opposing factions, you should be careful that half of them are facing one group and half of them are facing the other group. Not everybody faces one direction. That sends the signal that you're protecting both sides of things. But I think the tools are relatively limited in my view. Now, just one real quick thing. I was surprised when I did my research on this. This is one of those places where most of us know the Supreme Court decisions, but as we know, for every Supreme Court decision, there's 150 Court of Appeals and district court decisions and things like that. When you're a litigator, you get involved in a case, you read them all, but we're not normally aware. So it's amazing across the country the trigger for requiring a permit, and in many places, a gathering of more than 10 people will require a permit. Or maybe 25, but it's a relatively small number. There's very thin law on it. There is case law on it, but it's very thin, and the courts have tended to be pro-government in permitting a relatively low number as the trigger. Now, there's an interesting problem, and there's not a whole lot of law on this, and that is you have to somehow allow for spontaneous non-permitting gatherings. There's a First Amendment right to suddenly want to protest some event that has just arisen, and you can't require a permit to protest police violence for a murder that happened. And so anyway, I probably too long an answer.
I want to return to do you think there's any more or any leeway for universities to proceed differently? I know that UNC was supposed to have one of these speakers, Milo.
Right.
I think, and I believe the school. I know other schools did this. They denied access on the risk of violence, and I think the risk was more of the counter protesters than the actual speaker. But of course, the reality is, and I'm sorry to be so cynical about it, but the reality is that there's just massive opposition to having these speakers on campus, and university administrators are under tremendous pressure not to permit these speakers, to find a way to keep them off campus. And I find this personally very troubling, but I'm wondering what you think about that.
Yeah, I find it troubling as well. And so if you think about it, as government officials, which Mary Rose, you are, I know you may have you work for the University of North Carolina.
Don't sue me for libel, though.
Yeah. As a government official, you're not supposed to even have in the back of your mind, I want to keep these dudes off the campus. I mean, you're not supposed to have a viewpoint discrimination intent. Your obligation is to protect these principles of content and viewpoint neutrality. So you're limited, I think, to the time, place, and manner levers that you can pull. Now, obviously, there's interesting debates over the public forum status of American campuses, and I love this famous quote from Bart Giamatti, who some of you remember as the commissioner of baseball, and I remember as the president of Yale. He was one of my professors when I went to Yale as an undergraduate, and he called Yale a free and ordered space, and it's juxtaposition of its kind of open forum notion and it being ordered. So I think you have some triggers you can pull there, but I think it's a disaster to disinvite a controversial speaker. And sometimes we have to stand up for this notion that even speakers we condemn are entitled to be as part on our forums.
Yeah, I think you and I are a little old school on this, and maybe most of the people on this call too. I hear a lot of calls, particularly among the students, but believe me, not limited to just students, the faculty as well at a law school who think that we should be embracing the role of the university as not a neutral marketplace of ideas, but actually having to step in and having a role to play in deciding what speech is, passes some minimal test, I suppose, that some things are out of bounds and that we should not feel like we need to have them because universities are special places in that way.
Yeah, and listen, I often do this. I speak out of both sides of my mouth. I do. there's no question. I'm always so torn about things. So it turns out I went to Yale as a football player, but my daughter actually got there on her academic merit, and she graduated about 5 years ago, and so she was there at the height of tremendous tensions on that campus and a lot of student rebellion against all sorts of hate speech. And she was one of the campus leaders, really coming down hard on the administration for not doing more to keep the racist voices and the homophobic voices off the campus. And it was right around then that one of the really popular sayings, including from my friends at FIRE, were things like, "This generation doesn't understand free speech." And you may notice in my book, I think this is what happens when you have kids and they really fuss at you. I never said that in the book. I said they just understand it different, and they understand the university as what should be a rational place and a moral place and a value-laden place and a place that respects human dignity, which is a perfectly plausible way to understand free speech. It's one of the things I talk about in the book. It's one of the classic kind of counter versions to our more libertarian notion. And I would suspect that probably more current American college students would buy into my daughter's version of free speech more than they would me. And I find it very hard for me to sit on a high horse and say, you just don't understand it. And if it goes to the heart of what a university should be, and many parts of our university life, we wouldn't tolerate hate speech. You and I wouldn't tolerate it teaching a class, right? I assume we would tolerate any perspective on constitutional law and teaching the class, but we wouldn't tolerate people insulting each other with racial slurs in a classroom, I don't think. And so anyway, yeah.
Right. I like to think about the future of the First Amendment a lot. And I mean, right now we have a pretty conservative court that in general, aside from special classes of people like prisoners and students and employees, they're generally pretty speech protective. But we see some tensions. For example, like Justice Breyer, Justice Kagan seem to be moving or sometimes embracing these balancing tests. I think you called Breyer's approach a middling compromise approach. And sometimes I wonder taking a long view. So I don't mean next year or the year after that, but do you think that it's possible that given the prevalence, it seems in our society that back to this order and morality point of view of the First Amendment, that it should be counterbalanced against, say, equality, that we should recognize more harms, like emotional harms and those sorts of things, like that the court over time might shift its jurisprudence to be a little less speech protective, or at least have a different sort of First Amendment analysis?
Right. So I think the answer is no. And one of my pet theories over the years has been that the two counter theories of free speech that I identify, the first I call the marketplace theory. That may be a bad name for it, but it's the modern First Amendment with Brandenburg and Cohen versus California and flag burning cases and cross burning cases and Stevens case and Snyder versus Phelps. So all that very strongly pro-free speech, highly protective body of doctrines, which has been embraced by so many of the conservative justices. Chief Justice John Roberts is probably as strong an advocate of that view as any justice in the history of the court, in my view. But the counter view, which is that order and morality should weigh in, and you should be able to ban speech that is either contrary to public order or that we think is reprehensible, is alive and well in these settings outside the general marketplace. That's really what drives public employee law. That's what drives the school speech cases. It drives these other pockets where we say, all right, check the F-bomb at the door. You're not allowed to wear that inside the courtroom. You wear it outside in the corridor, but not there. We're not going to allow personal insults in this space. This is a workspace. This is all right. So what I think you may see is that boundary dispute shifting a bit. I have every bit of confidence that for the foreseeable future, for as long as I'm ever going to be doing this, that modern libertarian marketplace Holmes theory is never going to give way. I mean, if you think about it on the Supreme Court today, occasionally a justice will deviate from it. Justice Alito in the Westboro case, Justice Thomas, in the case I argued in Virginia versus Black, or some of the middle justices who are a bit ambivalent. I mean, you have to remember Justice Kagan argued the Stevens case, and kind of invoked that order and morality balancing of Chaplinsky, and was pretty severely chastised by the Chief Justice in that case. Said it's a dangerous view, not just it's wrong, it's dangerous. The government's view is dangerous, but I don't see it gaining traction. And this is one of those rare areas of constitutional law where, at least in the general marketplace, conservative Republican judges and justices may be as strong as the liberals are strong. So that's my take.
Yeah. Before we turn it over to questions, I wanted to focus on this marketplace of idea. I think the book says Confessions of a Free Speech Lawyer. And I think one I already mentioned, I think it was a realization of the harm of monuments, and just like really understanding in a way you hadn't maybe fully understood the plight of Black America. But switching to the First Amendment, maybe some of the weaknesses of this marketplace of ideas theory.
Right.
So although you're confident it's going to go forward, I think that it's at bottom it's because you're worried about trusting the government, and not as much confidence in the effectiveness of counter speech, or maybe even that we should be wary of the heckler's veto. There's maybe the traditional justifications, or some of the traditional justifications, don't hold water as much as maybe they did before.
And I don't think that I'm alone or even original there. And a lot of folks have made this observation. I really poignantly quoted Leslie Kendrick, who's a professor at UVA, because she's lived through all of this. And there was a point in which she said, I'm Jewish and I'm a free speech lawyer, and I had to see my community, roiled by all of this. And I think what you heard, what I said, but I'm not at all unique in this. I don't. If you ask me, does the marketplace work in the sense that truth emerges? No, not necessarily. I mean, evil sometimes emerges, lies sometimes emerge. The marketplace often malfunctions, and I'm not sure even Justice Holmes was really saying he thought truth would emerge. He said it was the best test of truth, but he didn't necessarily believe it would emerge. But I think the legitimacy argument is ultimately the argument, and once you put government in charge of deciding, then you invite trouble. Now, my daughter would say, an intelligent society and a decent society and a moral society can distinguish between good and evil, and can make those judgments. And yes, I understand that in the past, sometimes the wrong judgment's been made, but on the whole, we'd probably get it right. That there's something to that. There's some power to that. And in many, and I guess I'll leave by saying this, and I know we want to let people come in. Lee Bollinger said something like this a long time ago when he did some of his writings about the duality between the rules governing print media and the rules governing broadcast media. And he suggested maybe two different systems is a good thing. Maybe it's perfectly okay to have parts of our thinking be governed by this kind of wide open market, but to have other places where we want the programming to be in the public interest and so on. And I think you're hearing me say something like that as a lawyer training other lawyers how to comport themselves in our profession, I'm an order and morality guy. I have no problem with that. As a teacher, Crosby, Stills, and Nash, teach your children well. I'm an order and morality parent. And I think having that blend of different parts of our society where we have different expectations is probably normal and healthy.
Yeah, it seems like social media is a place we expect to be more sensorial. And anyway, that's one view I have.
It's a parallel debate, and the whole debate over Section 230 and all of that business. It's another iteration of some of these very things we've been talking about.
That's right. All right. Well, Seth, do you want to give the instructions for the Q&A?
Sure. So there's two ways to ask a question. One is in the fourth icon that I was referring to at the bottom of your screen, which is the person with holding the books or whatever it is. If you click on that icon, you will get a list of participants and you'll see the panel, but at the bottom right of that window, you'll see a little hand. If you click on that hand, it will tell Mary Rose that you want to ask a question, and she can call on you, and then we'll unmute you and you can ask your question and engage with Rod and Mary Rose. The other way to do it is to send a chat, and Ron and I will try and monitor the chat and interject at appropriate junctures to indicate that there's a question on the chat so they don't have to watch that while they're trying to answer the questions. So with that, we'll open it up to questions. And Ron, if you have one and you want to get us started, feel free. You have to unmute yourself, though.
Yeah. Well, thank you both for that robust exchange that got my mind thinking about a lot of things.
Great, thank you.
Let me just ask you this. We're all basically on the same First Amendment team, but a dissent is always welcome. So tell me, how does racism, blatant racism, advance the pursuit of truth in the marketplace of ideas?
Yeah, I think what you just heard me say is it doesn't. I can't see no way that I can say it does. So it doesn't advance truth, and so you have to have other reasons for permitting it. And I think the basic reason is because we don't. Floyd's books have made this point. Floyd Abrams' books have made this point. If you're going to censor that, then who do you trust to censor it? And I think that's the better explanation for why we let it go. I also will say this, Ron. I do think there is something to the Brandeis notion that if you suppress it, you may make it worse. The analogy I use is kudzu, which if you live in this part of the United States, if you try to cut kudzu out, and it just comes back stronger. And I think that that's the justification. But I don't see any way that the kind of really extreme, ugly, rancid, racist, and anti-Semitic and homophobic speech that we see so much of out there does anything other than inflame passions and hatred.
The reason I mention it is because, as you both may know, this, for lack of a better word, Trump card is so often mentioned in court opinions and Supreme Court opinions. I mean, it appears frequently, including in the Roberts Court, and it just seems to fly in the face. I mean, obviously there are other justifications, but it seems that this. And what's interesting about Holmes is, as you pointed out, he said it was an experiment, but experiments fail. And so I guess the point I'm trying to make is that notwithstanding your comments, the fact is that this marketplace of ideas is quite often used by the Supreme Court and lower courts to justify. I mean, obviously there are other reasons, but this one is used quite frequently to justify a particular result in a given case. And that was my only point.
Yeah. And just a real quick, let's not blame law clerks and Supreme Court justices from just following legal doctrine. I mean, that's what you tend to do, and you tend to follow. We all use the same platitudes. But if you just take three of the modern cases, the Westboro Church, Snyder versus Phelps case, the Crush video case, United States versus Stevens, and Alvarez, the false military honors case, there's not a dime's worth of value to any of that speech. There's zero value. You can't possibly posit any value to watching animals get crushed with, or the Westboro Church's stuff or anything. So so let me put it this way. I think the justices must know. Somebody like Chief Justice Roberts must know. It's not because I think this stuff has any value. It's because I don't think we require it to have any value.
We do have some questions lining up. So first question is Frederick Lane and then Francesca Procaccini. So Frederick?
Thank you very much, Mary Rose, and thank you, Rod, for taking the time to speak with us today. I really enjoyed your book, Deliberate Intent, so it's nice to have a chance to speak with you. Just as a tiny bit of background, I'm working on a book called The Rise of the Digital Mob, which is looking at the impact of digital technology on society and our interactions with each other. And one of the issues I'm grappling with, I think, goes to directly what you're talking about, which is the issue of whether or not technology has fundamentally changed the First Amendment game. So it's one thing for us to, and I'm not an originalist by any stretch of the imagination, but the concept of the First Amendment coming out of the 18th century, when you had Ben Franklin printing things and they took 2 months to get to wherever, is so profoundly different from what we're dealing with right now. And I'm grappling with this issue of disinformation and misinformation and serious harm resulting from the speed of communication. I'd love your thoughts on how that's changing the game, and if we need to figure out a reframing of the First Amendment in light of that.
Right. So I think it's changing the game. You're absolutely right. The harder question is, should it change the doctrine?
Right.
And right now where I'm at is, that doesn't mean, obviously doesn't mean I'm right, but right now where I'm at, no, let's not say it changes the doctrine, but it might change the application of law to fact in a particular circumstance. And so let me go back to Charlottesville. There's a civil suit going on right now by a number of folks under the Federal Ku Klux Klan Act and a Virginia similar law against the organizers of the alt-right rally. And a lot of what's in the backdrop there is exactly what you described. The brilliance of the alt-right folks in their logistical use of digital media to organize this rally. I'm content saying let's have the rules of the game not change. You apply Brandenburg versus Ohio, you apply Virginia versus Black, but do it with realism. And if some of the things you've described show us this is not abstract advocacy, this is calculated, organizing to cause harm, and that's where the proof takes you, then you may see punishment for the speech. But I think it's a terrific question. My instinct right now, and of course a lot of folks disagree with us, but my instinct right now is it's not the doctrine that changes, but how we perceive that doctrine playing out in a particular set of facts can be influenced by the kind of game-changing qualities that you've described.
Excellent. Thank you.
Yeah, in those civil case, the online communications between the defendants are actually really coming home to roost against them in a way that if they weren't online, you may not have seen it. So this isn't to cut against your question, Frederick, which is amazing. It really goes to the heart of what's happening today. I just meant to add there is a little bit on the other side as well, where if this suit does go against these defendants or continues to go against them, their online speech is being used against them. Maybe we need to debate that more. But all right, Francesca, you are up.
Hi, thank you so much for this discussion. So I kind of wanted to link up two strands of what you guys were talking about. One is the heckler's veto doctrine with some of the things we're saying about the intergenerational divide, shall we say, amongst free speech purists and those who are seeing it a little bit differently. And I guess, and I was struck by what you were saying about how some of the younger faith leaders in your research were the ones calling for, direct action against the racist speech. And I guess I think part of why the younger generation, of which I admit, I guess I'm slightly part of to some degree, and I have some sympathies towards, the election of Trump was a big deal. That's an actionable thing that happened that we are all living under. And I think a lot of us would say, who knows, but a lot of us would argue that that is a direct result of the fact that a lot of ideology was left to itself and wasn't combated in the way that I think we saw the counter protests, right now, but also in Charlottesville, as you described. And so I'm wondering if I guess my real question is, the future of the heckler's veto doctrine. Do you see a very strong place for that going forward? Either arguing for it or also just sort of, look in the looking glass and see, is the new generation going to take issue with that? And there's nothing in the First Amendment that requires us to subsidize speech that we don't like, even if we have to allow it. So I'm just curious for your thoughts on how those two strands are going to come together.
So thank you. That's a great question. And first, let me just comment on the cultural side, because I think you're entirely right. The election of Donald Trump caused, negative reverberations across large segments of our society. And there were people in favor of the president's election and against the president's election on American campuses, but generally more were against. And certainly at the University of Virginia, that was the case. And I already mentioned in those early days of the Trump presidency, in which there was a determination in many progressive circles to do everything they could to fight what they perceived as an immoral agenda by the president on issues like immigration and race and class and so on. UVA and Charlottesville were center points of that resistance. So there's no question that you're absolutely right, that part of what drove folks to engage in the counter protests, including the younger clergy members in Charlottesville, but many others, was the fear that this was a very pernicious ideology that was creeping and gaining too much traction in the country, and the fear that there was an alignment between the extreme right-wing supremacists and the president, and that he was encouraging them through code and saw them as feeding his base and appealing to some of the larger political cards that he was playing. So I think your cultural observation is exactly right. Now, I think if I understand your heckler's veto question, my reaction would be you don't shut either side down, and you don't permit either side to shut the other side down. And what that then means is the right social policy position and the right legal position is to permit both sides to speak. But to go back to a point that Mary Rose and I were talking about when we were chatting, it doesn't mean the leaders have to be passive. And you may say, yeah, I got to let these folks on my campus, but you don't have to be quiet if you're the dean of the law school. You don't have to be quiet if you're the university president in saying what you think about their views. And you got to be careful. You can't be commenting on every controversial speaker that comes onto the campus. but so anyway, I hope that somewhat answers your question, Fran.
Yeah, no, thank you. That's great.
While we wait for other people like my former student Lauren Russell to raise her hand, I want to ask you a little bit, Rod, more about whether you are concerned about the use of statements on social media to support convictions or civil liability for violence that results. And I appreciate that the alt-right, I don't want, maybe somewhat special case. I mean, it does appear that their whole mode was to pretend they were going to go on the defensive, but actually were really planning to be offensive. But you could easily imagine other groups that maybe speak with some hyperbole online, or make other statements in the safety of their little groups online or their little community, like, we're going to take those streets, like we've seen in some of the cases where the court held the speech wasn't actionable. Are you at all worried? I mean, it's easy not to be worried about this hateful group, but do you have any concerns about that being used against other groups that may be on, Black Lives Matter activists, for example, if they end up in defending themselves, for example?
Well, I am, and it occurred to groups on both sides. There's a recent Fifth Circuit decision that I think is probably, in my view, unsound, that said that a civil suit could go forward for what appeared to me to be nothing more than essentially pure political speech or planning a rally. So I am very concerned, and I don't think we want to see abstract advocacy, even when worded in extreme ways in social media, lose its constitutional protection. And so what I would demand, and what I think the plaintiffs believe they can prove in the Charlottesville case, is the more classic who, what, when, where of conspiring to provoke violence in a sort of deliberate way that crosses from advocacy to crime.
I don't see any questions right now, unless
You have another one.
I do? Okay.
Yeah, David
Who is it?
David Keating. Go ahead, David.
Yeah, hi. And there's someone who's also asked a question in the chat. It's important. I was unaware of this civil suit, and it's been alluded to several times. So if you could elaborate on that a bit more, and what the standards are. I mean, it sounds like a lot of us are supporters of anti-SLAPP laws. And this type of suit is used in a way to target unpopular views. Is there a way to dismiss such suits early on and prevent discovery, which can be very burdensome to people who may not have counsel or can't afford decent counsel?
So you were coming in and out a little bit, but I think I heard both questions. And so I'll try to give fairly succinct answers to both questions. The civil case is in front of a federal district judge in the Western District of Virginia, Judge Moon, and he wrote a long and thoughtful opinion on a motion to dismiss. The suit is brought under an ancient federal civil rights law, a part of the Ku Klux Klan Act. We all know Section 1983. This is Section 1985. And it begins in the famous language, whosoever shall dress up in disguise and go out on the highway to conspire to violate the civil rights of folks. And Judge Moon was very thoughtful in his opinion, in my view. He dismissed many of the counts and dismissed some of the defendants, saying your comments are abstract advocacy, and they were racist and they were suggestive of violence, but you cannot sue someone for that. The First Amendment protects you. But then there were very detailed allegations of detailed logistical planning that appeared to provoke violence. And he said, and that is not protected by the First Amendment. And if the proof is there, the intent is there, it can go forward. The case is heading to the Fourth Circuit. I'm sure it could easily be in the U.S. Supreme Court before long. But So that's the suit, and I commend to you the opinion. The opinion's very thoughtful and nuanced, I think. And your second question very quickly involved other officials in Charlottesville, and the biggest showdown, and maybe this is a good place for us to end, because I know I'm a Chicago guy, I'm a union guy, I only work for 90 minutes and then it's overtime. But as the alt-right rally was approaching, Charlottesville officials sought to move the rallies from these downtown squares in Charlottesville near UVA, which are pretty compact and pretty tiny, to a wooded area. And I remember this, I used to take my kids there. That's a big kind of sort of state park with big baseball diamonds and hiking trails and so on, where there wouldn't have been that sense of compression, and you could have kept the parties apart, and there was parking at a local high school, and it would have been much less scary, an area called McIntyre Park. And the federal district judge in the Western District, Judge Conrad, ruled against the city, saying, this is really viewpoint discrimination. You really don't want these racists in the center of the city, and refused to allow the city to move the rally. Officials probably made other kinds of mistakes. They're not the kinds of things that I find it easy to condemn them for, because it's so difficult to make these calls in advance of something that's this fluid and have this kind of sudden build up to it. So that's my best response, and I'll turn things back to our leaders here.
I wanted to ask you about guns. We didn't talk about that with weapons, and this will bring us back to the current events. So the Raleigh police released a statement today saying no one should bring any weapons, any guns or any weapon. I can't remember. It was definitely no guns, and loaded or unloaded, no guns at all. And in your book, it says you supported the commission that you served on after the fact, a recommendation banning loaded weapons but permitting weapons. And I know your book is not about First and Second Amendment. It's a small piece of your book, but I'm sure it's of interest to our audience. Just if you could talk a little bit about your rationale for allowing guns, but not loaded guns. It seemed to me, I wasn't sure why that.
Well, so it harkens back to a war story that was very I still wear this scar. I argued the true threat case in the United States Supreme Court, Virginia versus Black, and in this pretty, to use Ron's favorite word, robust exchange between Justice Scalia and I, Justice Scalia was coming very strongly at me about how a burning cross is as frightening to a person of color and as threatening to a person of color as a gun. And I fought back. I said there is a fundamental difference. The reason the gun is frightening is that if you don't know whether or not it's loaded, you could be killed by it. But the cross can't hurt you. The cross may be threatening harm down the road, but the cross itself can't hurt you. And then he asked me about an unloaded gun, and we went down that road. So here's the reason I think you might have a right to bring an unloaded gun. The police can check to see if there's ammunition, is that the gun itself could be a symbol. I mean, if it's an NRA rally, they want to bring their guns as symbols of the right to bear arms. The reason I argued that I felt nothing in the Second Amendment prevents the government from disarming a group at a permitted rally is that once it is a permitted rally, it becomes it's almost like going into Madison Square Garden or you're at a venue that is no longer a public forum in a sense. It's a public forum that's now been rented out for this event, so to speak. And you can have safety checks. You can prevent people from bringing alcohol in. You can prevent people from bringing bombs in. You can prevent people from bringing guns in. We wouldn't think twice about being checked for that when we go to a football game or a concert. And I took the position that given events in modern times, at least a permitted rally where there are access points that the police decide to have, the Second Amendment shouldn't be understood as prohibiting weapons there. And I took that from that famous paragraph written by Justice Scalia in the Heller decision, in which he talked about these settings that would not necessarily be places where you could bring weapons, sensitive areas. And he mentioned schools and government buildings and so on. And I said I thought the Second Amendment was pliable enough to allow that. There is a Virginia Supreme Court opinion that said that Virginia state universities could keep guns off their campus using that language. Now, I could be right or I could be wrong. We'll have to wait for the next Second Amendment opinion of the U.S. Supreme Court. But that was my view, and I'm sticking to it.
All right. I do see. Do you mind if we have Tar Heel Lauren Russell ask her question? I did call her out, and she's stood up.
I'll keep my answer short. I see we got the 5-minute warning, so I'll keep my answer.
All right, Lauren.
Sure. Hi, Professor Papandrea. Good to see you. I was wondering if you could talk a little bit more about low value speech. I hear you that you don't think that there's any point in attaching value to speech, and it seems like the court is drifting away from that. But what do we do now with the fact that we have the concept of low value speech in these different categories of it?
Right. So there are lots of case books out there through which people teach First Amendment, and a lot of them are organized, and they have a chapter that talks about low value speech. But mine doesn't. So I've never bought into that way of thinking about free speech. I think the whole point of the modern marketplace theory is that the government cannot make those judgments. Now, it doesn't explain all the First Amendment law. So obscenity law still is there as an exception to these concepts. But generally, I don't believe that's the way we should think about it. High value gets this level of protection, low value gets less protection. What I think is more sensible is to gerrymander the marketplace. So we have areas in which anything goes, essentially, short of incitement to riot or threats. And then we have areas where we are permitted to make value judgments, like the inside of a middle school classroom. And that's the better way to think about
it. Thanks.
You got an A, Lauren. Good job.
Yeah,
Next question.
You were taught by somebody that really knew what they were talking about.
So is there anybody else before we sign off? And I'm happy to say that Floyd Abrams had a little difficulty joining us, but he has been with us now for a while in any event. And so Floyd, if you did want to make a comment, I would certainly make that option available to you. But if not, we're certainly not going to compel speech, certainly. But while we're thinking, I just want to remind folks to kind of echo what Seth said earlier, that on July 21st, we'll have Floyd Abrams engaged in dialogue with Paul Clement, and we're very much looking forward to that. This First Amendment Salon, like all others, is recorded and videoed, so you can go to the First Amendment Salons on the FIRE website. And if you missed Jamil Jaffer and Noah Feldman on our last salon, it's really an incredible exchange, as was this one. And so a big thank you to Mary Rose and to Rod and to everybody else who made this possible. We very much appreciate it. And again, the book is Confessions of a Free Speech Lawyer. And I encourage all of those who, any of you who haven't yet bought it, to do so. And with that, I'm done on my end. Seth?
I have nothing to add.
We are adjourned.